prospects of a Bongbong Marcos presidency just went brighter and more certain, with the last legal hurdle cleared against his candidacy. And as PTV's Karen Villanda reports, the full body's first division that handed down its ruling on the latest settled disqualification case had a familiar face who penned an earlier and much controversial decision over a protest on moral turpitude and failure to file income tax returns.
The Commission on Elections has dismissed the remaining disqualification case in the division level against presidential candidate Ferdinand Bongbong Marcos Jr. This comes after Comelec First Division released a ruling today denying the petition of Pudno Nga Ilocano for the disqualification case against Marcos for not filing his income tax returns from 1982 to 1985. The 25-page ruling was signed by Presiding Commissioner Socorro Inting, Commissioner Amy Ferrolido, and Commissioner Amy Neri. The resolution showed the commissioners are not convinced that non-filing of the ITR is considered as moral turpitude. It was also based on the Supreme Court ruling on Republic versus Marcos. The First Division added that such act is not inherently wrong, since the failure of not filing the ITR is just an obligation made by law. In the previous ruling of the Supreme Court, evasion of taxes is a crime involving moral turpitude. But according to the division, not filing of the ITR is not considered as tax evasion. And even if Marcos will not file his ITR repeatedly, he pays his taxes through the withholding system. The First Division was not convinced that Marcos was convicted of a crime with more than 18 months of imprisonment, a reason to disqualify him. This is due to the existing law of the failure to file return, which provides a penalty of fine and imprisonment not more than 6 months and 1 day. The division also clarified that Marcos is not perpetually disqualified to hold public office, vote, and participate in elections. The Court of Appeals did not impose imprisonment but only issued a fine for not filing the ITR. The resolution can still be appealed to the Commission and back. Karen Villanda for The Nation.